Judgment in the matter of Valeriy Drelle against Servis-Terminal.
Lord Hamlin will explain this judgment.
For a creditor to present a bankruptcy petition against a debtor, Section 267 of the Insolvency Act 1986, which I shall refer to as the 1986 Act, requires that the petition is in respect of one or more, quote, debts owed by the debtor to the petitioner creditor. This appeal concerns whether an unrecognised and unregisterable foreign judgment for a debt or definite sum of money can constitute such a, quote, debt. An unrecognised foreign judgment is a judgment of a foreign court that has not been made subject to recognition in proceedings in the UK. An unregisterable foreign judgment is a judgment of a foreign court which is not subject to any statutory registration process in the UK, for example, under the Foreign Judgments Reciprocal Enforcement Act 1933 or the 1933 Act. The foreign judgment relied upon in this appeal is a judgment of the Arbitrage Court of Yaroslavl region in Russia, which ruled that the respondent, Mr Drelle, had breached his duties to the appellant, Servis-Terminal LLC or ST, when he was ST's Director General, and the court ordered him to pay 2 billion rubles to ST, which I shall refer to as the Russian judgment. Following the Russian judgment, Mr Drelle commenced multiple appeals in Russia. However, the Russian courts dismissed them. In October 2020, ST served a statutory demand and a bankruptcy petition under the 1986 Act on the basis of the Russian judgment. Mr Drelle unsuccessfully sought to set aside the statutory demand in the UK Insolvency and Companies Court, or the ICC, on the grounds that the Russian judgment debt was disputed on bona fide and substantial grounds. The ICC judge rejected those claims and made a bankruptcy order against Mr Drelle. Mr Drelle appealed to the High Court, alongside challenging the ICC judge's conclusion on his grounds for disputing the Russian judgment. Mr Drelle argued that since it was unrecognised, the Russian judgment could not constitute a debt under Section 267 of the 1986 Act, unless and until it had been recognised in proceedings in the UK. The High Court disagreed and dismissed the appeal. Mr Drelle appealed to the Court of Appeal, who allowed the appeal. The court held that an unrecognised foreign judgment, like the Russian judgment, could not provide a basis for a bankruptcy petition. ST now appeals to the Supreme Court. In its judgment, the Supreme Court unanimously allows the appeal. Lord Briggs and I give the judgment, with which Lord Sales, Lord Stevens and Lord Doherty agree. The court orders that Mr Drelle's grounds of appeal, which sought to challenge the ICC judge's conclusions as to whether the Russian judgment debt was disputed on bona fide and substantial grounds, should be remitted to the Court of Appeal. The first question is, what is the effect at common law of an unrecognised and unregisterable foreign judgment for a debt or definite sum of money? The parties did not dispute that the Russian judgment was a foreign judgment given by a court of competent jurisdiction and is otherwise final and conclusive. On the basis of the rulings of the ICC judge, it is also not impeachable. In such circumstances, a foreign judgment for a debt or definite sum of money, like the Russian judgment, gives rise to an immediate obligation at common law on the foreign judgment debtor to pay the judgment sum, and this obligation does not depend upon recognition of the foreign judgment. This principle, labelled the obligation principle, is the juridical basis upon which a foreign judgment creditor may bring an action in England and Wales based on that foreign judgment. For brevity, I will hereafter refer to England and Wales as England. The obligation principle was clearly established in court decisions in the 19th century and has been reiterated in modern authorities. Accordingly, the Court of Appeal were incorrect to suggest that a foreign judgment, like the Russian judgment, has no legal effect at common law until it is recognised, as this would be contrary to the obligation principle. The Court also rejects the Court of Appeal's reliance on Rule 45 of the leading textbook of Dicey, Morris and Collins on the conflict of laws, which states that a foreign judgment has no, quote, direct operation in England. This rule is referring to the fact that a foreign judgment does not have the same status as a judgment in England, such that none of the modes of execution which are available for an English judgment can be invoked in respect of it. It does not mean that a foreign judgment has no legal effect in England. Finally, the Court of Appeal's significant reliance on the revenue rule, whereby the English courts have no jurisdiction to enforce penal or revenue laws of another country, was misplaced. The enforcement of a foreign judgment in England concerning a private right does not involve any act of a sovereign character, any exercise or enforcement of a sovereign right, or any vindication of sovereign power, with the result that the revenue rule and the principles underlying it are of no relevance. In the light of the Court's answer to that first question, the second question is whether such a foreign judgment gives rise to a debt under Section 267 of the 1986 Act. The general common law meaning of a debt is wide, being a legal obligation to pay a sum of money to another person. Before, during and after the enactment of the 1986 Act, the common law also considered that such an unrecognised foreign judgment gave rise to a legal obligation to pay the sum concerned. This obligation was consequently understood at common law as a debt. There are no convincing reasons to suggest that a narrow interpretation of debt was intended. While Section 6 of the 1933 Act has been held to prohibit relying on an unregistered but registrable foreign judgment to initiate bankruptcy proceedings, the 1933 Act did not impact the position of unrecognised and unregistrable foreign judgments at common law. ST additionally argues that Article 13 of the United Nations Commission on International Trade Law of the 30th of May 1997, or the Model Law, given effect by Regulation 2.1 of the Cross-Border Insolvency Regulations of 2006, requires a creditor relying on a foreign judgment to be treated the same as a creditor relying on an English judgment. As the latter would be a debt under Section 267 of the 1986 Act, it is argued that the former must be too. However, the reference to foreign creditors in paragraph 1 of Article 13 of the Model Law is concerned with the geographical location of the foreign creditor, not with the law under which they are owed a debt. Accordingly, its anti-discrimination provision has no bearing as to whether a foreign or British creditor can commence bankruptcy proceedings relying on an unrecognised foreign judgment.
The Court is now adjourned.